Calling our next case, People v. Jones. Good morning, council. This is a 15-minute mini oral argument on the application. You have 2 minutes of a free fire zone, which you may waive, and if you're going to save time for rebuttal, we ask that you keep track of your own time.
Yeah, I do want to reserve time for rebuttal. So, and I don't think I'm going to even use full 10 minutes. Okay, now, and by the way, may it please the court, my name is Daniel Bremer. I represent Mr. Jones. Now, as I said in my brief, I think that you can make kind of a contractual analogy in this case, in which and there are plenty of ambiguities in this case as to what the agreement was. That any ambiguity should be held against the judge. I hate to say against the judge, but the drafter of the Cobb's agreement. And a Cobb's agreement is kind of an unusual kind of contract, to the extent it's a contract at all, in that it's not negotiated. It's all or nothing. The judge makes a proposal, and the defendant can ask for clarity. And maybe they should have in this case, but the defendant cannot negotiate with the judge, and that's totally outside the parameters of Cobb's. Does not allow that, does not want that. Now, so what happened here was this went over 2 different days, November 19th and 20th. On the 19th, there was what the judge described as a hybrid offer, which by itself is a bit confusing, of a Killebrew agreement and a Cobb's agreement. And here the assistant prosecutor said that he would not object to a sentence at the bottom of the guidelines. He didn't mention a specific number, but he spoke of the bottom of the guidelines, which at that time, all parties thought was 29 months. And then the judge explains to the defendant what that meant, and that he already had 4 months of jail credit, and that probably would mean something like 25 months. All right, so the defendant rejects that. The next day, he changes his mind. The prosecutor is not willing to re-extend the Killebrew agreement, so now the judge makes I guess what you could call a pure Cobb's evaluation. Now, and here, unfortunately, we have a lot of ambiguity of language. Now, the judge did not specify a particular range, but she spoke of the lower end of the guidelines. You know, she didn't say low end or bottom, she said lower end. All right. But she then also spoke of what the offer was yesterday, which was frankly unclear because there's this hybrid that she spoke of.
What is it that you're asking trial judges to say? What are the words that need to be said to make this clear? Because, I mean, an argument has been made that this was on the lower end. I could see if it was, 80 or 90 months, that looks more like the middle or closer to the top. So what is it that you're looking for judges to say, or what number would have been acceptable that it was on the lower end?
Okay, I think the judge should either say low end, that is bottom of the guidelines, or a specific number, or if the judge wants to say a range would be acceptable, the judge should inform the defendant what the range would be, which could be...
So the first one that you said, let's take them one by one. So the first one that you said is low end. So, and that's pretty, it's pretty close to what was said here. So what is considered the low end?
Well, that's ambiguous, frankly. Some people would think that's the very bottom of the guidelines. Some would think that means within perhaps the lower half of the guideline range. I think the judge should just make it as clear as possible what the judge is offering.
But, and so one of the options was a specific number. We don't really want to tie trial judges to a specific number, especially in a situation where where that range may be different, right?
No,
I mean, it went up a little bit here.
Yeah, I'm just saying that's an option the judge could follow is a specific number.
And so, back to my question of lower end, what number would have been acceptable here to be considered in the lower end?
Well, the problem is it's ambiguous. The defendant didn't understand. He thought the judge meant 29 months.
But the judge said lower end. The judge
Lower
didn't
end.
say the very bottom number.
Right, she didn't say that, no. My point is that a competent evaluation ought to be as clear as possible. And when there's ambiguities, it should be resolved in favor of the defendant.
And so that's what we're here talking about is what direction, if we are to give direction to trial court judges, what is that direction? I mean,
Okay.
it needs to be clear,
Yeah,
you know.
okay. I think they have several options. One is a number. Another option would be to specify, okay, here's the range I'm looking at. 29 months to 50 months or whatever it might be. It's just that it ought to be clear to the defendant what the offer is, because the defendant's not in a position to actually negotiate with the judge. It's pretty much take or to leave it. He can ask for clarity, but he cannot negotiate with the judge. I'm just saying it has to, I don't think it's handicapping judges to ask them to make it clear what their offer is. They don't have, the judge does not have to offer a number, a specific number, but just let the defendant know what the range is that the judge is considering.
Counsel,
And that would be fine. It's just-
I happen to agree with you, what you just said. I think it judges more clarity is better.
Yeah.
And numerically quantifiable offers are better, either a specific number or a specific numerically quantifiable range. We don't get that in every case, and there is no strict rule requiring it. My question for you in this case is, did anyone ever tell your client he was going to get 29 months?
No.
So why are we here?
Well, because it's ambiguous. No one said 29 months. That would be one thing, but there are ambiguities. One. the day
On
before-
the previous day, we had a prosecutor's plea offer, and then the judge she said, and the request was made of me, if we were able to secure by a plea, that I would stay in the lower end of that range.
Yeah.
So isn't that discussion already, the notion being, look, even if you agree to something with the, I think the prosecutor, by the way, only said that they would not object. Guidelines still are 29 on the absolute minimum. Let's see, the guilty as charged. I would not have objected to defense requests for the court to go to the bottom of the guidelines.
Right.
So the prosecutor is not capping the sentence, just saying I won't object to your request, Mr. Defense Counsel and Mr. Defendant. And the judge is saying on the first day already, talking about staying in the lower end of that range, which could be, the lower half, the lower third, the lower quarter, any of those things, but your client received a sentence that would qualify, did he not?
It would be within the lower half of the guideline range, yes, that's correct.
Or lower third, or even the lower
Yeah.
quarter, right?
However, the judge also said that this was a quote-unquote hybrid Killigrew-Cobbs degree. In other words, she's more or less incorporating with what the prosecutor is saying to what she's saying. So the problem, she says both of these things, both that we're staying the lower end, and the prosecutor here has said the bottom of the guidelines, which at that time they thought was 29 months. Now, he didn't give a number, but he said bottom of the guidelines. Okay, so the problem is all around these ambiguities, and that can be straightened out. I think it's possible to not tie judges to specific numbers, but just to require clarity, that they have to specify, if they mean the lower half of the guidelines, they should say that. So unless there's any questions, I'm just going to stop at this point.
Reserve your time. Okay, thank you.
Okay.
May it please this court, Janet McLaren on behalf of the people. The Cobb's agreement in this case did not specify a minimum specific sentence, and therefore it does not trigger the defendant's right to withdraw his plea under Cobb's. All of the discussions regarding this agreement were that the court would stay on the low end of the guidelines. A defendant should not be allowed to withdraw his plea because he does not get exactly what he hoped for, as long as he gets what he bargained for. And in this case, the defendant got exactly what he bargained for. The trial court, when discussing the guidelines range, used language that made it clear that these guidelines were not set in stone. While not using the specific language that they might be different than preliminarily scored, the court did indicate that they were roughly scored. That's the word that the court used. There was no agreement as to what the actual guidelines would be or what the specific sentence would be, and the court did adhere to the agreement for the low end of the guidelines. This agreement is clear for appellate review. Again, the court did not say the absolute bottom. The court did not say the lowest point. Rather, the court agreed to not sentence to the high end, but to the low end. As Judges Gleicher, Borrello, and Krause noted, the 50-month sentence is much closer to the calculated 29 or 36-month low end of his range rather than to the 114 or 142-month high end. And allowing the defendant to withdraw his plea would actually be contrary to the prevailing law of Cobb's. In the Cobb's case, the court contemplated that things change, that often preliminary considerations are not in existence at the time of the sentencing, and that does not bind the judge's discretion as long as the defendant, unless the defendant relied upon a preliminary evaluation and the judge later decides that the sentence must exceed the preliminary evaluation, which did not happen here. As the court noted at sentencing when there was some objection, she indicated that the court did stay within the Cobb's evaluation and agreement, and the court did do that. The court did not exceed the preliminary evaluation, sentenced on the low end of the guidelines, and no abuse of discretion occurred here. We would ask that you would affirm the Court of Appeals decision.
So I understand, I don't know that you've conceded it, but I think that you agree that the judge could have been more clear.
Absolutely.
And that there is language that could be used that can, give defendants, more clarity when hearing what the Cobb's agreement is. If we agree with you, and we all agree that they could have been more clear, but we deny leave anyway, what are we supposed to do, and what are our options about these cases that will keep coming to the court? Is there another avenue that we can address this? Because unless a judge, you say low end, unless the judge is like right at the high end or in the the middle, or however judges are looking at this, or the Court of Appeals is looking at it, seems like there's a lot of issues with clarity and knowing how to really address this.
Ambiguity, as defense counsel.
I try not to use that word.
Yeah. So I think an appropriate remedy for something like this, that the court wants to fashion something going forward, would perhaps be an amendment to a court rule. I don't think it's a good idea to fetter the plea agreement process by saying you have to have a specific number. And in fact, Cobb's contemplated that things are going to change. And because we don't often know exactly what sentencing guidelines are going to be, they're somewhat subjective. The Department of Corrections gets to decide that. I know that's happened to me in scoring guidelines where I'm quite sure that I'm correct, and then when the guidelines come back, they surprise me sometimes, or they know something that I don't. Right? They find out something that happens that I didn't know. So I don't think it's a good idea to say they have to state a specific number, but perhaps indicate that specifically this could be different instead of using the words roughly or saying we preliminarily scored. Perhaps a court rule amendment saying that they must tell the defendant in a Cobb's agreement these guidelines might change. So what you're looking at may not be specifically what I'm telling you at this point.
Cobb is unique to Michigan. Other states don't have anything like this. And it's not even uniformly used across the state of Michigan. Why don't we just get rid of Cobb's altogether?
I still think it's an effective bargaining tool for the defendant as well. Most
But
times.
we keep getting these cases up in here. Well, we got rid of Cobb pleas altogether, we wouldn't have these cases.
I think it's an alternative, but I think a lot of defendants like to know that they're going to be sentenced at the low end as opposed to the high end. I think it is beneficial. It's a useful tool for all parties.
So, I mean, that point, and I agree with you, so it is useful to know not just, the range and if the range changes, but as you just said, it's useful to know, is it low end, is it high end? That ambiguity or vagueness is why we're here, why we run into this. So I guess your suggestion that maybe a court rule is a better place to address it. How do you address that low end, high end? I mean, do we get specific? Do we have to say it's, the lower quartile? Is it how do we even do that in the context of a rule to avoid this sort of issue as well?
Well, I think that the low end would obviously, for me anyway, would be that you're not going above the halfway point. That would be what I would argue if I were to argue it, but I can see I understand your point. And you could be that specific, I suppose, in a court rule, but I think that would be, at least it would clarify what the court is looking to do. If there was a court rule letting them know specifically guidelines might change, and often do.
Mm-hmm.
So what happens if the Cobb's agreement is based on those preliminary guidelines, and let's use 29 as that bottom number, and then when they're scored, they come out much higher? And even if the judge stays at the bottom, the low end there, we're talking about, from that initial number, it's actually the high end. What do we do with a situation like that?
Well,
Because, you look at a defendant,
And
how are they entering that plea knowingly if they are thinking,
Right, and
low
I
end?
think what you're asking me, if I'm not correct, was actually addressed in one of the cases that Brother Counsel indicated, where the court said that a sentence that's in the upper end of the lower half is not the low end of the guidelines, and I would agree that was correctly decided.
But I'm asking, when you have the preliminary guidelines, and then you have the guidelines that come back from the Department of Corrections.
Sure.
And if they change, drastically
Dramatically.
enough, where now, instead of being in the low end, even if they're in the low end of the new guidelines, they're now in the upper, end of the previous one that defendant thought he was agreeing to.
I think you're still getting the benefit of the bargain if the court indicates, I'm going to stay on the low end of the guidelines, whatever those might be, as opposed to the high end of the guidelines. I still think that the defendant that would enter into a Cobb's under those circumstances would be getting the benefit of the bargain, even though the numbers changed, and as happened here too, even though the numbers changed, they would still get the benefit of the bargain if that was the Cobb's agreement, that you'll get the low end.
Would the Genesee County criminal docket be backlogged if we did away with Cobb's altogether?
More backlogged? Yes.
Okay, fair enough.
Yes, I believe it would.
How
Now,
often
we do
is-
have some judges
How often is
that,
the Cobb being used in Genesee County?
we do have some judges who are not amenable to it, and, are loath to use it. But I think we use it quite often.
Sort of comes into play when the prosecutor is less willing to offer either sentence agreements or reductions. So it's,
Absolutely.
Right, the prosecutor's office really controls whether there's going to be a plea or not.
True. True.
well, not necessarily. The defendant can plead guilty to the principal charge under a Cobb scenario if they have a good idea of what the sentence is going to be.
Right. I thought he meant if there wasn't a Cobb's, then that would be
Correct.
true.
That's exactly what I meant, thank you.
Yes. If there are no other questions,
I don't see any. Thank you very much.
Okay, I just want to make a few brief points. In a normal Cobb situation, when it turns out that the judge receives information that the judge didn't have at the time of the plea, then the defendant's allowed to withdraw his plea. Now, as to a situation where, turns out the guidelines are much higher than was anticipated, the judge should, at the time of taking the plea, let the defendant know that the guidelines could be calculated at a higher rate, at a higher number, and that the judge is not agreeing to a specific range. I think that would solve that problem. So I don't think there's any need to do away with the Cobb's rule. I just think it's necessary to provide some guidance that we don't have these ambiguous situations come up anymore like this. It can be, it's very avoidable.
Are you asking for a different remedy other than withdraw the plea?
Yes, I'm asking for enforcement of the original agreement.
We've never done that with the Cobbs, have we?
Not that I'm aware of, no.
What was the
Enforcement of
original-
the original agreement.
We don't know what the
what
original
is-
agreement
yeah,
was.
what-
Well, as a secondary remedy, I would ask that you allow him to withdraw his plea, yes. Okay, any other questions? Or
Not for me.
okay, thank you.
I have just a quick one. Are you familiar with the Cobb's agreements where the agreement would say, the guidelines are subject to change, but if they change, you're still going to be bound by the correctly scored guidelines? Are you familiar with Cobb's agreements like that, or?
Oh, yeah, yeah, and that's perfectly okay.
Yeah, that's acceptable to you?
Sure.
That was my question. As long as the defendant knows that the numbers could change, but
Yes.
whatever the numbers are, the numbers are.
Yes, yes.
Okay, thank you.
Okay, thank you.
Okay, thank you. The case will be submitted.